Our last section of the class on protection of intellectual property has to do with the protection of trade secrets. Now, you have some things that you do in your business that are unique and they've been developed by you. You've spent a lot of time and money developing them, like maybe you've paid thousands of dollars for an employee to go out and make sales calls on all of the people that buy your product, and now you have a customer list and you know which customers buy from you and which ones don't, and how much they buy, and what's the name of their purchasing agent, and what's his wife's name and his kid's name, what's his favorite hobby. You have a tremendous amount of marketing intelligence that you have gathered over the years, and that is your customer list. You can't patent or copyright that customer list, but it has special value to your company, and it would be a detriment or harmful to you if some other competitor got hold of that list. So your trade secrets are protected by law, and when some employee of your company leaves, he can't take that customer list with him and give it to his new employer or offer it to his new employer to help him get a job, because that is a trade secret. It's protected by law. What kinds of things are trade secrets? Well, customer lists, plans, research and development, pricing information, marketing methods, production techniques, anything that a company puts together that's unique to them and would have value to a competitor is basically a trade secret. Trade secrets are not only protected in the common law, and you can sue in the court, but they are also a crime. To steal trade secrets is a crime under the Economic Espionage Act of 1996. So there's two things I want you to know about trade secrets for test purposes in this course. One is that you do have legal protection for your trade secrets. That's an important concept. But the other one is that unfortunately in the past few years, employers have been using confidentiality agreements in an abusive way that renders some employees unemployable when they leave that place of employment. So what am I talking about? Well, if you come to work for someone and they have you sign a confidentiality agreement, there's no problem with that. They're just saying you're going to obey the law. And when you leave, all of the customer lists and production plans, things that you developed while you were working for that company, that's the exclusive property of that company, and you're going to leave it there when you leave. You're not going to take any trade secrets with you, and you're not going to give them away. So to be asked to sign a confidentiality agreement with regard to trade secrets, that's not really a big problem. That's okay. But in the highly competitive fields where people are really competing for the really good employees, like software design companies that are looking for the best computer programmers. If you're one of the best computer programmers and you go to work for Acme Company, when you leave there, they don't want you working for Beta Company. And so they can't stop you from working there. In California, it is illegal for an employer to have an employee sign a covenant not to compete. Remember, well, maybe you don't know this yet, but in the sale of a business, it's okay, as between the buyer and the seller of a business, for the buyer to get the seller to sign a limited covenant not to compete. And we'll get into that when we talk about sale of a business at the end of the course. But for an employer to try to halt an employee from working for anyone else when they leave that place of employment, that's illegal, because our policy is we don't want to render workers unemployable. But the employers have come up with a clever way to circumvent that law and render employees unemployable. And the way they do that is in the confidentiality agreement that they ask an employee to sign. They add another clause, and it's the automatic injunction clause. Normally, if an employer wants to stop a former employee from giving away trade secrets, he has to sue them. And if he wins the lawsuit, he can get an injunction, a court order that says you can't give away those trade secrets. But what they had people sign was they said, look, by the time we go all the way through a trial and get a court order that you cannot give away those trade secrets, it's too late. You've already given them away. So what we want you to do is sign a contract ahead of time that says If you give away our trade secrets, it will be irreparable harm, and we don't have to go through the whole court process. You're agreeing ahead of time by contract that we can get a pre-trial injunction from the court stopping you from going to work for any competitor of ours and from giving away any of the trade secrets until after we have a trial to determine whether or not you should be allowed to work for that employer. So what happens is when you leave that place of employment and you go down the street to work somewhere else, if you're working for another software design company and they don't want you working there, they go down to the court and they get a pre-trial injunction, a court order that says you cannot work there. Well, if you take them to trial, you can probably beat that as long as you're not giving away trade secrets. But in the meantime, you are unemployable. You can't work at that company, and it's going to take you a year or two to get to trial, and you're going to be unemployed the whole time you're waiting to get to trial, and it's going to cost you thousands of dollars in legal fees to fight that. So usually your former employer has won that legal battle on the day they go down and get the pre-trial injunction enjoining you from working for Beta Company. What you do is you give up and you go find a job in some other career field because you can no longer work anywhere in the software design field because this guy's got you with this clause he put into the contract. So if you ever are asked to sign a confidentiality agreement as a prospective employee, take that thing down and have a lawyer look at it before you sign it. And if it has a clause in it that says you're agreeing to a pre-trial injunction without your day in court first, you tell them the lawyer Litchfield said that's an attempt to violate and circumvent the law in this state, which says that you cannot render a former employee unemployable through a form of covenant not to compete, and you should refuse to sign that. Now, if you want the job badly enough, you may have to sign it anyway. But I'm telling you right now, if you ever leave that company, they may decide they're not going to allow you to work at any other similar company that does the same kind of job you like to do. So you may end up being forced to get a job outside of your chosen career field because of this current abuse of the confidentiality agreement in employee contracts in California. That's it for protection of intellectual property.